Introduction to Tort Law. Welcome back to my channel, and if you are a new subscriber, welcome to Miss Legal Eagle. In today's topic, I am going to summarise what I have learned so far in Part 1 of Tort Law. I hope you will find my study notes helpful, and please remember to contribute in the comment section below anything that you would like to share around this topic, or indeed anything around the SQE. We can learn better through collaboration of information through varied resources we use to study. I will issue this disclaimer. I am not a qualified legal practitioner and do not give legal advice. I have, however, studied law to master's level and currently work within the legal sector. I am also a student, like many of you here, who are studying for their SQE exam. The content on my channel are my own notes that I have made as I study, and then I type them out to share with you. The voice narrating is my own cloned voice, generated by AI to use in order to read my script for me. I use this platform as a study group to connect with other students studying the same. If you would like any further information on studying for the SQE and qualifying as a solicitor in the United Kingdom, then please ask me in the comment section below, and I will do my best to answer your questions. I can also guide you to any textbooks and other resources that can assist you learn on your SQE study journey. I will strongly advise that you study in deeper detail using various portals of resources available for the SQE. On my channel, I am only summarising what I have learnt on the various SQE modules, as it helps me retain the information in my head as I share what I have studied on that topic so far. Do ensure that you watch my next video on Part 2 of Tort Law. So without further ado, let's get into learning tort law. Negligence is the most important tort. Negligence is a liability based on fault and careless conduct by the defendant. The objective of negligence is to provide compensation to the claimant. Compensation are damages awarded to the claimant to put them in the position they would have been in if the tort had not been committed. We need to remember the elements of negligence in order. The order is as follows: duty of care to claimant, breach of duty of care to claimant, cause of claimant's injury. Let's discuss them in a bit more detail, one at a time, starting firstly with duty of care to claimant. Established duty of care. There are what is called novel duty requirements that the claimant is required to show. We refer to these as three areas of duty of care. These are as follows: foreseeability, proximity, and fair, just and reasonable. Secondly, we look at breach of duty of care to claimant. It was very interesting for me when I was reading around the aspect of duty of care that there is another angle to the duty of care, which is omission or failure to act. So let's say a reasonably skilled professional, like a surgeon, fails to act in a manner that is expected of someone bestowing the skill set that a surgeon is expected to have. They may be found liable for omission or failure to act. When the court looks to balance whether the defendant has breached their duty of care, the courts use the balancing test. This analyses two aspects. These are magnitude of risk versus burden of taking precautions. Magnitude of risk. This looks at two things. These are likelihood of injury and gravity of the likely harm. Are you all still with me? Well, I hope so. The other aspect of tort law I read about was social utility of conduct. That is the social utility of the defendant's conduct. I will try and explain this with a scenario. I am the defendant in this scenario. Let's say my neighbour's car caught fire and I go to try and assist to put it out. My conduct was to try and assist to put the car fire out, and that would be the social utility of conduct on my part. Therefore, it is less likely that me as the defendant would be held to be negligent. Remember that the greater the social utility of conduct of the defendant's conduct, the less likely it is that the defendant will be held to be negligent. However, if I attempted to put out the car fire by using gasoline to do so, then there would be no social utility of conduct on my part, as I have made the situation worse. In this case, the defendant's activity has no social utility and it is unlawful. The third element of neglect is the cause of claimant's injury. I am learning a lot of Latin phrases ever since I have started the journey of studying law and the SQE. Res ipsa loquitur. Can you recall what that was? It translates to mean the thing speaks for itself. I will try and explain this with another scenario. I have a food manufacturing company that produces vegetable pies. Somehow, a small screw dislodges from one of the conveyor belts on the production line, and that screw ends up in one of the pies. You, as a customer, purchase that pie with the screw in it. As you eat through the pie, you bite into the screw and it badly damages your gum. Is the pie manufacturer negligent? What do you think? If your answer is yes, that is correct. They are negligent because you would not expect to find a metal screw in a pie. Now let's tie this up with what I have already mentioned at the start of this study session. Remember that I mentioned that the novel duty requirements are what the claimant is required to show that the defendant was negligent. These were foreseeability, proximity, fair, just, and reasonable. In this case of the metal screw being in the vegetable pie, the claimant is not required to prove these novel duty requirements. The res ipsa loquitur would apply in this case. The cause of the claimant's injury was the negligence of the defendant, which caused the claimant to suffer harm, and no intervening acts broke the chain of causation, and the harm was not too remote. The three requirements for res ipsa loquitur are: the cause of the incident is unknown, the thing causing damage was under the sole control of the defendant, and the type of occurrence would not happen without negligence. I would like to say please go and read much further, and around causation in fact and causation in law, as well as other areas of tort law. This brings a close to this very summarised overview of our study on tort law. It really helps me learn and prepare for my SQE too, when I go through these notes again to keep recapping on everything. I hope as you study with me, together we will learn to retain and recall information that will be extremely helpful in studying for the SQE exam. I look forward to you joining me in the next module. Remember to subscribe to my channel and hit the like button so we can continue to engage and draw others to our student platform to learn along with us. If you have any comments or other useful study points on the topic that could help other students, please make sure to post it in the comments section below. Till the next post, let's keep reading wide and well.